got so motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old thoughts on the block.
We're here in 25S000104. We have plaintiff Leslie Gomez present, and then we have Donna Britton present for New Spring Equities LLC. She is the representative in the matter, or they are the representative in this matter. Let me just see the docket really quickly. Okay. So today is procedural. We are looking to make sure that all documents have been filed correctly, and then we will go ahead and proceed after that. First and foremost, I'm looking at proof of service. I have declaration of service. It looks like the declarant served the above described documents upon New Spring Equities. And was the declarant Jamie Cook? Ms. Gomez?
Oh, correct.
Okay, thank you. Ms. Britton, you are aware then in this matter, it looks like you were the individual who was served upon that Ms. Gomez is seeking $1,115.27 in reimbursement, correct?
Yes.
Okay. So it looks like it is a request for a damage deposit or a deposit refund. I do find that there is correct documentation in regards to the procedure necessary to move forward in this matter. My next question would be, Ms. Britton, as representative for New Spring Equities, do you wish to contest this value, or do you wish to agree to this value and work with Ms. Gomez to refund that amount?
She's already been refunded that amount. She cashed a check for $1,000 on the 14th of July. That was inadvertently not given to her address. She and I agreed via email, where she says right here she's very happy that we came to the solution. So she came. I told her the check came back to my office, and I gave it to her. She cashed it, and now she still wants to proceed. So I'm not quite sure what she's expecting here.
Ms. Gomez, why are we proceeding?
So that email that she's referring to was sent on June 3rd. So I didn't receive a check until 41 days after, in which I had already filed a lawsuit for New Spring Equities.
So at this point, are we dismissing the case now that you have been paid?
I do not want to dismiss the case because she still didn't so they failed to contain the documentation required pursuant to RCW.
I'm not asking for laws.
5918.
I'm just saying that if you're asking for $1,115.27 and they refunded you $1,000, you are going a lawsuit over $115.27.
Well, according to the law, it says the court in its discretion might award up to 2 times the amount of the deposit.
And it's my discretion, if you've been awarded your damage deposit back, that you're not going to get 2 times the amount. That's frivolous.
Well, is there any way that I could get at least my full deposit back?
Miss Britton, because I don't want to waste my time on this. This seems ridiculous that you've gotten it returned and you're still here trying to sue them. So Miss Britton, go ahead.
Actually, she's received more than that. So she received a check for $533.89 that was sent to her, and she cashed that check. That was sent on May 20th, and then she received again another $1,000. So she's received more than the $1,100 she's asking for.
Do you want to add anything, Miss Gomez?
Yes, New Spring Properties has given me a total of $1,533.89. So what I was thinking today, if I could just get the rest to add up to my $2,000 deposit.
That's not what you're requesting. What you're requesting is $1,115.27. And Miss Britton is saying that you.
That was I'm so sorry to interrupt. That was the original amount before she has sent that check.
Okay, so then the difference would be 100. You are suing her for $115.27.
I just want, basically the full amount of my deposit minus the 1,533.89 that she already sent me.
So I am asking you, what amount are you asking for then?
One moment. Let me just pull out a calculator. 1 second. $466 with 11 cents.
Miss Britton, okay, so now you know her amount. Either we can go to trial over this, or do you wish to just pay that in its entirety? Because we can go to trial over this.
Yeah, I understand, but we also paid her utility bill of $384.73.
Okay. Well, you know what? You can file a counterclaim against her and ask her to reimburse you money at this point as well. And if you want to do that, I will leave time for you to file a claim against her for those amounts. Because if she's asking for that amount, but you also paid her utility bills off, you have the legal right to sue her for that money back as well. So, do we both wish to proceed over that amount, or would you like me to give you some extra time to file a counterclaim against her?
Well, if she's expecting me to give her that much money, I will do a counterclaim against her for the utility bill. Absolutely. The owner
Okay.
shouldn't have to pay for that.
Okay. All right. So at this time, I will actually go ahead and allow for, I believe, Mr. Clerk, is it 30 days to allow for a counterclaim to be filed, or what would it be?
Set trial.
Okay, so I can set trial and you can file a counterclaim, Miss Britton, and at that time I can decide whether you will be awarded the money back as well. So, Ms. Gomez, at this point, it looks like based on that information and what your numerical value you just presented, you're going over to trial for about $100 based on what your request is versus what Ms. Britton is staying for paying bills. I have no problem setting a trial for that. But in that meantime, Ms. Britton, you're able to file any counterclaims for values that you believe your business entity should be reimbursed for.
Okay.
So the soonest I have is September 24th at 3 p.m.
Okay.
Does that work for both parties?
Yeah.
Okay. So September 24th at 3 p.m., I will go ahead and schedule this in. So because we are scheduled for September 24th, that means that by September 12th, that's a Friday, all parties must submit any exhibits that they wish to use during trial or any evidence that they will use. That needs to be 2 copies of everything, so that way I can retain 1 copy and then the other copy can go to the other party, so that way they see what's being presented against them. Because I'm not setting a time for drop-off by September 12th, that means on the 15th of September, which is a Monday, all parties can come to the courthouse, the district court clerk's window, and pick up any exhibits that have been dropped off for them, okay? I want to clarify that September 12th, that is absolutely the last day for any exhibit drop-off, that you have more than enough time to drop off prior to then. And as I just stated, you can drop off any time before then as well. It's not just on the 12th that it must be dropped off. So any day up until September 12th, please drop off any exhibits, 2 copies of each. Miss Britton, if you wish to file that counterclaim, that paperwork can be just received here at the clerk's window, and it can be filed as well. It can be inclusive of any amounts you wish to seek against Miss Gomez. Okay. All right. Well, thank you for both of your times, and then we'll see each other on September 24th at 3 p.m.
Okay. Thank you.
Thank you.
Thank you.